centre has returned 20 names of judges recommended by the Supreme Court, raising questions over a fresh standoff between the judiciary and the government. Remember, Law Minister Kiran Rijiju has been criticizing the collegium system by which judges are appointed by fellow judges. Where will all this end? We're going to debate that in a moment, but first take a look at this report.
For years, the country has seen a tussle between the executive and judiciary for control over appointment of judges. Now, with the BJP government on the offensive, the confrontation is there for all to see. The centre has returned 20 recommendations made by the Supreme Court Collegium for appointment in various courts. Law Ministry sources say 11 of these files are of fresh names sent in the last few months. 9 are names that had earlier been sent back and have again been reiterated by the Collegium. Law Minister Kiran Rijiju had recently called the Collegian system of appointments opaque and sought more say for the government in appointments. A Supreme Court bench on Monday lashed out, slamming the centre for sitting on appointments. 68 names recommended by the Collegium since 2019 have still not been cleared by the centre. This when there are more than 400 vacancies in high courts. The Supreme Court has 28 judges against a sanctioned strength of 34, with more judges to retire in coming months. The legal fraternity is divided.
The collegium system may have its own flaws, but as long as the judgment stands, which is the law of the land, they have to honor, and the sending back of the names, especially the ones which is reiterated, definitely invites a clear contempt notice. So I'm expecting that to happen on the next day.
So it should not be just a one-way traffic. Both the government and the collegium should pull up its socks and should work together with each other so that the vacancy position can be improved.
More than 400 vacancies in the High Courts and the Supreme Court, and a confrontation brewing between the centre and the Supreme Court over judges' appointments. After the Law Minister has made certain statements about the Collegium, the Supreme Court also lashing out at the government for sitting on the recommendations. The country, however, is watching with bated breath to see when will this face-off be sorted out so that judges can be appointed and the cases pending for decades can be heard. In New Delhi, this is Anisha Mathur for India Today.
So let's raise the big questions. Is the centre undermining the Supreme Court by not going ahead with the recommendations made by the court? Is there a pick and choose approach to judges? Is the collegium system extra constitutional? Does it in a way ensure the judiciary's independence? Is it time for a new appointment mechanism? Joining me now, Justice A.K. Ganguly, formerly of the Supreme Court, and Siddharth Luthra, senior advocate who's also been Additional Solicitor General. Let's come to you, Justice Ganguly. Your view, do you believe that the collegium system has outlived its utility or is not effective as the Law Minister suggests? Or is the government trying to browbeat the judges into appointing those whom only the government wants?
You see, the collegium system was introduced as early as in 1993, reiterated in the presidential reference of 9 judges in 1998, and when that was sought to be replaced by NJSC Act by making an amendment of the Constitution, 99th Amendment, that was outlawed again by the Constitution made to the Supreme Court in 2016. So there are 3 judgments of Supreme Court, and since 94 onwards, the judges are appointed both to the High Court and the Supreme Court on the basis of a collegium system. To question that now is to raise your voice against the law which has been declared. It is the law of the land under Article 141 of the Constitution. What the Supreme Court declares is the law of the land. And
but laws can change. But laws can be amended. But Justice Ganguly, laws can be amended.
No,
laws are not in permanence. Laws can be amended.
Yes, unless, listen, yes, Unless it is amended, you have to follow it. You cannot disobey a law which is there, staring on your face, saying that it should be amended. That means, unless it is amended, you won't follow it. In the process, what are you doing? You are clogging the rule of law. Because people's right to go to court is being impeded because you are not appointing judges. This is a very, very unfortunate step taken by the government.
Can I bring in Siddharth Luthra
you
there?
You like the law, but that doesn't mean you will follow it.
Siddharth Luthra, do you believe?
Yes.
Do you believe, Siddharth Luthra, a solution can be found, or is this now heading for a direct face-off between the judiciary and the government, given the fact that the government has just returned, we are told, 20 more judicial appointments?
So the norm was that the government could return the names once, but if the Supreme Court sent them back, reiterated the names, the government would accept it, and that was the norm that used to be followed. What happened was, when the NJAC judgment came, there was a second round which was in relation to the memorandum of procedure, which at that stage the bench thought it best to leave it to the government. Now what is happening is that the government has been using the memorandum of procedure, which is the procedural aspects, to defer and to oppose certain names. Now, of course, the government is entitled, in the context of adverse intelligence reports or adverse or such adverse findings or unsuitability, to come back to the Supreme Court and say, look, we don't agree with this candidate and these are the reasons, and then the Supreme Court has to see the material and determine whether the government's justification is right or wrong. But what has happened over the last few years, I must say, is not only are judicial appointments being opposed, objected to, and not happening at the government's end, but there is also inordinate delay. We must remember, in a system of parliamentary democracy, there has to be a balance of power between the various institutions, and there has to be mutual respect for various institutions. The law minister may have a viewpoint that the collegium system needs replacement or needs change. That's his viewpoint. He's entitled as a constitutional authority to take that view. But till they bring in a new law, till they amend the law, that view of the law minister cannot be translated into a mass-scale opposition of appointment of judges. We have to understand the larger connotation. This is not about the law minister. This is also not just about the Supreme Court. This is about, Rajdeep, the common citizen's right to access of justice. Why are we working in a manner to try and impact the functioning of the judicial institution? Should it be a situation that by withholding appointments and delaying appointments, we ensure that citizens' access to justice is lost? That, with respect, I would say, is not good governance, is poor governance. And therefore, the intellectual debate between the executive and the judiciary, which is also going on in court.
Are you saying it's become an ego battle? Has it somewhere become an ego battle now? That the government of the day
I've
is
lost
saying,
you. Can you repeat?
Do you get a sense that this is an ego battle? That the government, in a sense, is trying to sort of show its muscle, that this is no longer about the law per se. It's becoming increasingly any name that, most names that come from the Supreme Court, we won't accept it unless you change the earlier collegium rules.
I think it's not about that. I think the government is possibly, and one should get the sense of that, is possibly planning and building a kind of momentum for bringing in a revised version of the NJAC, which they're entitled to do. There's no dispute on that. The law will come, it will be tested. It is possible that the government may be able to bring out a better system of appointment of judges than exists today. But till that law comes into force, can we have this lack of respect for the judicial institution? Can we have a situation where we are constantly trying to undermine each other, an institution? After all, we must remember, we, and including the government, not just citizens, have to go to the courts often to get justice. So therefore, I think it is time for the government to reconsider its view and perhaps realize that they're dealing with not just the respect for each other, institutions, but also depriving the citizen. And that's the most crucial lesson which I think needs to be remembered.
Justice Ganguly, what should the Supreme Court do in conclusion, if you can tell us? The Supreme Court, how far can it go in drawing a line with the government? Is there any way in which they can sort of send out a firmer message than they have so far? Or are we simply heading, as Siddharth Luthra says, to a situation where the government is building a mood for a revised collegium system?
No, the government can always come up with a revised system. I agree with Siddharth Luthra, and I also further agree with him that till such system is at place, the government has to follow the existing law because it affects the common man. And I disagree with you. It's not can't be a matter of ego where the constitutional functioning is at stake. It's a democracy. Common man has a right to approach court. You are stopping that, you are impeding that, because there are not sufficient judges. So this is a very serious area of functioning.
So
here you may not like the law. I can understand.
Well,
you may not like the law. You may come up with an alternative system, but till that system is in place, is passed by Parliament and is okayed by court, you cannot just say I will not obey the existing law. I mean, I am very. Mr. Rijiju is asking questions about the validity of the collegium system. How can he do so? He has taken oath by the Constitution. He has to abide by the Constitution, and Constitution. This is a part of the constitutional mechanism. This collegium system of appointment in view of Article 141, and he is asking question. Under which provision collegium system is permitted? I mean, he should read the judgment. I mean, the Supreme Court has given maximum time to the executive. And reading the excerpts from the judgment, I find the Supreme Court is pleading and requesting the AG and the SG to resolve this impasse. And the matter is coming up in the first week of December.
So what you are saying is it's time that it's. I hope that Mr. Kiran Rijiju is listening to the wise words of Siddharth Luthra and Justice Ganguly and listening to them and perhaps trying to find a way out rather than a confrontation. What is now required is conciliation. Can that be achieved? That's the big question.